SJC-13340, Commonwealth versus Derrell L. Fisher.
Okay, Attorney Wood, whenever you're ready.
Good morning. My name is Chauncey Wood. I have the honor of representing Derrell Fisher. I am joined today by two members of my firm, Caroline Alpert and Danya Fullerton, who helped write these briefs. And I'm also joined by Mr. Fisher's mother and his two aunts. I'd like to focus today on my third argument, the admission of Trooper O'Brien's lay identification opinion that Mr. Fisher was the person depicted in the surveillance video. Defense counsel made a timely and clear objection to the admission of Trooper O'Brien's identification opinion. So first, it's a preserved claim of error. Trooper O'Brien's identification opinion was the centerpiece of the Commonwealth's case against Mr. Fisher.
Mr. Wood, what do we do with the instruction at the end of the case? I get your objection, but this case is somewhat unique, unlike the other cases where there's an instruction at the end of the case about the, that's for you to decide. How do we weigh that?
I will, that is one of, there are 5 factors, I think, that undermine the admissibility of this opinion, and I think that instruction, if we're talking about the same thing, made it worse. So if we're talking about the same thing, and my goal is to get there in my 20 minutes. That's the 5th point. So this is a preserved claim.
You don't want to do it first?
I don't know.
I mean,
All right, so, all right,
It's just a
so,
thought.
that's fine. I hear what you're saying. Thank you for that.
Don't forget
Don't
the basic
don't look at
rules.
gift horse in the mouth, I guess, or this is what you care about.
I'm just asking.
Either way.
I
All
just
right.
want to get the impact of that instruction on your argument.
Here's the instruction that I'm talking about. See if we're talking about the same thing. The judge improperly instructed the jury to evaluate the reliability of Trooper O'Brien's opinion, using the same factors they would use to evaluate the reliability of an actual eyewitness identification. This created a false equivalency between O'Brien and an actual ID witness who must testify from memory. But in fact, Trooper O'Brien was in the same position as the jury because he was able to view the video and Fisher's appearance at booking as many times as he wanted. The reliability of his memory was not relevant. There were many other points, which I was going to cover before this, which do bear on the reliability of his unusual identification testimony. But his memory, like a normal eyewitness identification, was irrelevant. And precisely because he was in the same position as the jury.
Maybe we're speaking on 2 different instructions. I thought there was an instruction, please correct me if I'm wrong. I thought there was an instruction that said what's depicted in the video is up to you to determine.
I'm sure that he did say something to that effect,
Okay.
and I submit that in light of all of the factors in this case, to grossly oversimplify, the prejudice, all of this argument is that the admission of Trooper O'Brien's inadmissible, suggestive opinion was unfairly suggestive. And so the jury, as this court recognized in Wordsworth, hearing an opinion from a police officer with the imprimatur of authority, would defer to that police officer's opinion instead of their own. So it's fine for a judge to say, you make the final decision.
Your position is the damage is done.
That's right. That's right. But that other opinion, I'll come back to the other instruction, which is obviously different than what you're talking about. But the judge gave the other instruction, I think, is more important. Here's how you evaluate this. You evaluate it just like a normal eyewitness identification from memory. I saw the bad thing happen, and the question is your memory reliable? And the judge creates a false equivalency. And so the judge actually bolsters the reliability of this lay opinion because his memory is not at issue. But precisely because he's in the same position as the jury, it was unhelpful. So let me back up. So this is a preserved claim of error. Because it's the centerpiece, it's a material issue. And finally, a straightforward application of this court's precedent in Wordsworth and Davis, both decided after the trial of this case, demonstrate that Trooper O'Brien's identification opinion was inadmissible and in combination with the prosecutor's closing argument that it was reversible error. In other words, this single issue is dispositive of this case. We're not asking you to create new law or interpret complicated questions. A straightforward application
Isn't
of
there
this.
a lot of other ID evidence on this, on your client?
No.
Really?
The single pillar of this case
Well, but
is
I understand that you consider that the single pillar, but what is the other ID evidence against your client?
the videos.
Besides the videos?
There's,
Nothing?
with all due respect, there's nothing. So that what there is the other evidence against my client is a statement he made to the police during the takedown about consciousness of guilt. The police officer, we submit this shouldn't have even been admitted, but asks him, where were you on the night of the killing? I was at work. Turns out he wasn't at work. He works overnight at the airport. But he was at work the night before that, and he was at work the night after that. Could he have been confused? I think when surrounded by 10 police officers, yeah, he could have been confused. That's the other. And then he also received a text from the co-defendant. It's on the news. Respectfully, those three things, the videotape evidence, the consciousness of guilt statement, and the text from Epshad June are the only evidence linking my client. Indeed, all of the other evidence linking somebody to this crime linked Epshad June to this crime.
What about the bullets?
They were found in the car registered to Epshad June in the driveway of Epshad June's mother's house. Those linked somebody to this crime. They linked Epshad June to the crime. The police searched my client's house, and they found no clothing connecting him to the crime, to the guy in the surveillance video. They found no evidence, no proceeds of the crime. They found lots of evidence in searches. It was all the ID of the second victim, Ms. Gattuso, and I think other documents related from her, and they found the bullets. All of the evidence they found, and they also found clothing, I believe, linking Epshad June to the crime. Again, all of the physical evidence they found, literally all of it, was linking Epshad June to the crime. My briefing exhaustively goes through this, and so I refer you to my briefing of this central, crucial point, that all of the physical evidence, all of it, linked Epshad June, not my client. The cell phone evidence linked Epshad June to these crimes. There was lots of back and forth between each of the three victims and a cell phone number. That cell phone was Epshad June. There was zero cell phone evidence linking my client's cell phone to any of the victims. Again, the cell phone call he had that was arguably relevant to this case after the fact was Epshad June once texting my client saying, it's on the news. So, the admission of Trooper O'Brien's lay ID opinion, this was central because the most important piece of evidence was this video, really by far. And the thing that made that most prejudicial was this lay ID opinion, interpreting that. And for 5 different reasons, the admission of that opinion was reversible error. So, first of all, as a general evidentiary matter, lay opinion about factual questions are prohibited. A determination of the identity of a person depicted in a surveillance video is clearly a factual question normally left to the jury. Wordsworth makes clear that a lay identification opinion from a surveillance video must satisfy 2 separate, independent evidentiary rules to be admissible, 701 and 403. Trooper O'Brien's opinion satisfies neither.
Let's talk about those 2 things. Mm-hmm. So first, on the lay opinion testimony, the judge does a very good job of saying, I've looked at the video. It's clear, but it's not entirely something that the jury couldn't have some help on. And the judge makes a determination that it would be helpful to the jury's determination of identity to hear the trooper's testimony. So that we look and talk about whether there was an abuse of discretion. I understand you might disagree with it, but the other part is something different. It goes back to Justice Gaziano's point. In terms of doing the 403 analysis, one of the things that we look to is the limiting instruction. And there was a really powerful limiting instruction. Again, you might disagree with it, but there was a powerful limiting instruction that the judge gave that said, this person can say whatever they want to say, but ultimately it's still up to you to determine whether or not it establishes who the prosecution says it is in this video. So let's begin first. The 701, the helpfulness, the judge makes a determination. I've looked at the video, and I think it would be helpful.
So what Your Honor is referring to is a factor laid out in Commonwealth v. Pleas, an appeals court case, unmistakably clear. It must be in some middle. The video, the quality of the video must be in some middle ground, neither unmistakably clear nor so blurry to be useless. And he finds that's one factor, and he says, check, it meets that. But the problem with the judge's analysis is that there's a lot more to 701 than that. And there's two things. And he, frankly, commits reversible error on both of them, and they're independent. So if he's wrong about either one, that's reversible error. And he was wrong about both of them. So first, and this is not controversial, this is black letter law. 701, it requires two things. The lay identification witness, and again, this is an exception to the normal rule that you don't let in lay opinions, never mind from police officers. This lay opinion witness must have sufficient relevant familiarity with the defendant. Didn't have that. Second, the jury
Did have that.
No, with all
He
due
did have that. You're saying it came within the context. You're discounting it because it came within the context of the investigation. But he had met with your client in the Burger King. He had had opportunity to talk to your client. And so the idea of whether or not he had familiarity, if you want to discount it because it came within the context of the investigation, that's fine. But this is a judgment that the judge makes that is satisfied.
Well, with all due respect, of course, I'm here appealing a judge's decision. I don't mean to be personally disrespectful to the judge. I disagree with the judge. And the case law is clear that his definition of familiarity that he used was wrong. The relevant definition, and I'm citing this court's precedent. This court's precedent in Wordsworth makes clear, and Vatcher and other cases, makes clear that the relevant familiarity here is familiarity with the defendant before the video was created. The whole point of this is that familiarity, that prior familiarity, which the jury can't possess, gives the witness a power to make an identification. The fact that he saw Mr. Fisher at the Burger King after he had viewed the surveillance videos dozens and dozens of times, after he had gathered evidence, after two other police officers had seen Mr. Fisher in clearly the car that in a suggestive circumstance, and interviewed and said to him, "I think that's the guy in the video," and made his identification saw Mr. Fisher for the first time in that incredibly biasing context, and saw him for 3 or 4 minutes. That's his own testimony, which we cite in our brief. That is not the familiarity. And familiarity developed after you have seen the videos is quite simply not the familiarity this court was describing in Wordsworth and Vatcher. So that is the judge's first error. He is simply wrong under this court's prior precedent about his definition of familiarity. Secondly, the other issue, that a familiarity, and that by itself is reversible error. The fact that he had no prior familiarity with Mr. Fisher is reversible error. Vatcher, Wordsworth. But secondly, he also had to satisfy, even if he had prior familiarity, and this is Austin, even if he had prior familiarity, it's that the jury could not also possess. Because again, this is an exception to the normal rule that on factual questions, we let jurors decide the factual questions like this, like identification of the guy in the video. That the jury could not also possess. That was just wrong. The court's claim that the jury didn't have that is just simply wrong. I cite to the Commonwealth Supplemental Record Appendix, pages 151 to 154. They're actually in color, but this is theirs. They had, as soon as Mr. Fisher was arrested, He was taken to the police station, and they did booking photos. They didn't do just normal booking photos. They did full color, full body, and close-up booking photos. The point of this is that the jury knew exactly what Mr. Fisher looked like at the time of the crimes. The point is that this witness, this police officer, had no information that the jury couldn't also possess. Again, I'm citing Wordsworth and Vatcher, and most importantly, Austin's recognition that even if this officer has prior familiarity, he can't testify to this opinion because of the danger of prejudice. If he's not adding anything, the jury can't figure out themselves.
In Austin, they couldn't really see the video very
Sorry?
well. The video wasn't very clear at all in Austin that the police officer looked
So
at.
I take your point, Your Honor. If I could recharacterize that, you're saying the video here wasn't what if the video is really good? Isn't that important? And what I would say is, first of all, the prosecution, don't take my word for it, the quality of the video. The prosecution did, as they were required to do by the law, argue that this was not unmistakably clear. The judge found, as he was required by the law, that this was not unmistakably clear. And the only reason the prosecutor's allowed to argue this whole point is the finding that this is not unmistakably clear. So it's a question. It's a legitimate factual question. And the prosecutor, because it wasn't unmistakably clear, had to rely on, or chose to rely on, the distinctive braids and the unique appearance. Not look at his face, you can tell it's him, but look at the braids, and literally 3 times. She used it 3 times. And then his unique appearance, by which she means the braids. So clearly, the prosecutor understood that video, and this is not me, the prosecutor understood that video was not dispositive. And so the question ultimately is not, could a jury, and this is the most important thing, the question is not, could a jury reasonably have concluded, beyond a reasonable doubt, that looking at this video, that was Derrell Fisher? That's not the issue. Defense counsel moved to exclude this, and the court denied that request. The question is whether, if that was inadmissible, if that opinion was inadmissible, did the erroneous admission influence the jury's opinion about that, or did it have but very slight effect? And so I need to go back to why, all the reasons why this opinion had, well, there's a couple different things. I want to go back to 403. Your Honor correctly hit the guideposts, 701 and 403. I've covered 701, 403, and you noted, Justice Georges, that there was the limiting instruction. The limiting instruction, as I've already said, was the judge's effort. But there was a huge amount of prejudice here that couldn't be cured by any limiting instruction. So first of all, in any 403 analysis, you start with the probative value. For the reasons I've already indicated, there was no probative value. He didn't have any familiarity with this person, and it was not, whatever he had, it wasn't familiarity that the jury could possess itself because of these these booking photos. He didn't add any value. But now let's look at the prejudice prong.
Counsel, before you go on to the prejudice prong, you mentioned in the supplemental appendix, did your client have a hat on in the booking photos?
He does not have a hat on. And so I'm going to get to that. That's important and helpful to us. There are the sources of prejudice. And this is very helpful because Wordsworth had the exact same sources of prejudice. So you don't need to take my word for it about whether this was prejudice. Wordsworth had the exact same points of prejudice. First, the identification opinion was of a police officer who brings a greater imprimatur of authority. I've already talked about that. Justice Gaziano mentioned this in the Brum argument. This is the super witness, the police officer who marches in and says, let me tell you the answer to the question here, the ultimate question, who did this? That guy. That's what this really is. That's incredibly prejudicial. And the court, again, that's not Chauncey Wood's rhetoric. That's the court, although it is. But that's this court's decision. That's precedent. That's boring old appellate precedent. SJC Wordsworth. Secondly, in Wordsworth, the court noted that the officer offered bolstering, specifically the officers. They viewed this video footage 4 or 5 times, over and over and repeatedly, suggesting their opinions concerning its content merited greater weight than that of the jurors. In our case, O'Brien testified he watched this video dozens of times, so worse.
In Wordsworth, we had the charts with, look at the sneaker and all that. I tried the Doherty case, the Cody. So here, I guess the only distinction between this case and Wordsworth would be the limited instruction, which didn't happen in Wordsworth, correct?
Well, I mean, so...
I know you're saying the limited instruction was faulty, but is that the distinction?
Well,
the only distinction between this case and Wordsworth?
So you're referring in Wordsworth, I don't know this specific point, but if what you're saying is one of the police officers actually went through the exercise of pointing out points of similarity,
Yeah.
that's actually helpful.
Yeah, because in Wordsworth, they had a blow-up of, of a grainy thing, and then the defendant, they said, all right, stripe on sneaker, sneaker.
Right. That sort of thing is arguably more permissible. Here, my first point, before I get to your point, is that didn't happen here. That O'Brien didn't make any effort to point out, I think I'm overstating it. I mean, I think he might have
Here we have a police officer says, that's him.
Yeah.
As opposed to look
exactly,
at the thing.
exactly. It's the larger, let me step back and say, conclusion, that's him. That's the biggest problem. But beyond that, I mean, there are lots of similarities to Wordsworth, which was a reversal. The limiting instruction, I don't know the answer about the limiting instruction. I take your word for it that there was no limiting instruction in Wordsworth.
That's my memory, but I could be wrong
I don't
as well.
know.
Right.
I don't know.
Also, Wordsworth, we had 4 different police officers in Wordsworth doing it, right? We had, it was done by 4 different cops.
Yeah, I mean, the cumulative effect, this was the lead investigator, and he said, I watched it dozens and dozens of times. I don't think that that's a material distinction. I think that it's clear that he was the case officer, and his opinion, he was brought in as the superhero to give the opinion. But there's more. That in Wordsworth, I want to point out the similarities to Wordsworth. There's just 2 more, so bear with me. I know I'm over. The prosecutor elicited O'Brien's lay ID opinion before the jury could watch the surveillance video themselves, creating cognitive bias in the jury. This is complicated, and so rather than spend a lot of time on it, I lay it out in the chronology at page 31 of my reply brief. But the point is, the prosecutor elicits from the witness, what are we going to see in this video? You're going to see the defendant. Okay, now show them the video. What are they going to see? They're going to see the defendant in this matching exercise. In Wordsworth, this court recognized that's priming, which creates cognitive bias. Court's words, not mine. The exact same thing happened here. And then finally, the improper testimony in this case was extensive and went to the central issue. Again, Wordsworth notes 3 things: extensive, central to the Commonwealth's case, and the prosecutor focused on it in closing arguments. All 3 points, the same in our case. Extensive. Trooper O'Brien offered this opinion 5 times. The ADA adopted it 5 more times. So to the question of materiality, Your Honor, 4 witnesses, okay, I don't know how many times they said it, but we got 10 references in O'Brien's testimony to this.
There is a difference when 4 people say, this is the guy, as opposed to 1 person saying it's a guy. I mean, people have trouble disagreeing with when 4 different people say it's that. Versus, okay, that's his opinion versus my opinion, right? There is a difference.
I respectfully submit that, at least on the facts of the record of this case, the importance of Trooper O'Brien and the length of his testimony, that it's not a material difference. That's my respectful opinion. It was extensive, in my view. It was central. There was no other evidence that placed Fisher at the scene. And third, the prosecutor focused on it in closing. And I know I'm out of time, but I think this is crucial. She didn't just focus on it in closing. She violated this court's second relevant precedent on this case, Davis. Now, I'm not in the business of defending prosecutors, but I will note that Ms. Lynch made this argument before the court decided Davis, for whatever that's worth. But I think she was, well, I'm not going to strike that. In any event,
I'm going to ask you to
okay.
pare it down because you are almost 5 minutes.
Distinctive braids and unique appearance. We have a black man, and first of all, he's wearing a hat. Now, Your Honor asked about the hat. The hat is a problem for the Commonwealth because the hat, as the scientific evidence indicates, when you cover the hairline, you make it more obscuring. There's no evidence linking Mr. Fisher to that hat, to any hat. So this accomplice in the video wearing a hat makes it more difficult to engage in this matching exercise. It's not relevant. It's irrelevant. It's harmful. I mean, it's relevant because it's harmful. But so the point, though, on the distinctive braids is all you can see is about an inch of what look like braids underneath the hat. And so what she's saying are distinctive braids are about that much, about an inch of braids underneath the hat. Davis, the braids went all the way down to mid-back. So arguably, that's more distinctive. This is not distinctive, and it's not unique. And I submit that that was clearly an error.
Chief, could I
Yep.
may I ask a couple follow-up questions? Because you seem to be backing into the 701 issue. Because if all of this is true, doesn't that bolster the judge's determination that this would be helpful to the jury on the issue of identification? If all you're saying is this, because there was testimony from the girlfriend that she had braided Mr. Fisher's hair within some proximity to the night of the crime, you have this issue where you're saying by your own argument that the hat makes it a little bit more difficult to do this matching thing. The matching thing that you say they could do without O'Brien's help on the video versus the booking video, that we could do this matching thing, but I think you just conceded that you couldn't really do that because of the hat. So again, it seems to back in this issue that the judge did not abuse his discretion in making the determination that the trooper's testimony would be helpful to the issue of identification. But this is the point I want to get to. If you accept that out and you say that there's no other testimony that puts Mr. Fisher at the scene, you still have the other ones that we didn't get into because it's the issue with the motion to suppress. The consciousness of guilt evidence of the statements that Mr. Fisher makes. Now, I couldn't necessarily tell from your argument in your brief. Are you still saying it's a totality of the circumstances consideration on adding the groom factors to the issue of race? Because I mentioned that because it seems as if in your brief you elevate race over the other groom issues because the testimony was short. It was only about a couple different things. All of the other things seemed to militate in favor that it wasn't custodial, that it wasn't coercive, all of the other factors we go into. So is it just race? Is race the super element in the totality of the circumstances?
So, Your Honor covered a huge amount of ground, and I'm going to start with the question you clearly want answered, respectfully. This is the first issue in the brief. The answer to your question is, it sounds, so I'm not elevating race over the other groom factors. What I'm saying is that the court should add, and its add is even, I think, unnecessary. It's clear from JDL, that the court is supposed to consider all of the relevant factors. And so I think what I'm saying is that among them, in addition to all the groom factors recognized, in addition to what JDL says, the court, as part of what JDL says, the court should include race in that determination.
May I ask you, because I should know this, but is the affidavit in support of the motion to suppress in the record?
I don't know, and I'm happy to, if it's not, I'm happy to.
Well, I'm asking because does your client raise in the affidavit that because of the disparity between me and all of these white officers, that I found that my willingness to speak was overborne by the circumstances that I found myself in that Burger King parking lot?
Again, I don't want to guess. I have no idea about the answer to that question. And on the issue of, I think you also touched on.
Matter as to whether this is preserved?
We're talking, so sorry. I think you're on, I'm trying to follow the thread. I think you're asking if Mr. Fisher didn't complain about the racial issues feeling intimidated by the police officers as a young black man, we've waived the claim that you should consider race. Is that the argument?
I don't know that it's the argument, but what I think it does is it gives the Commonwealth to be on notice that I've got to now marshal evidence to demonstrate that race had nothing to do with this. However it is that they can. In terms of, initially when you started, you said that Mr. Fisher was surrounded by 10 officers in this parking lot. And as I read the testimony in the motion to suppress hearing, that wherever it happened, it was one, maybe two officers. There were some other officers that were told to leave from another community. There was another set of police officers from another community that were watching the road. So this idea, again, of demonstrating to the court that it's not 10 people surrounding this gentleman, it's giving the Commonwealth an opportunity to defend against the fact that it wasn't race.
I think that there's so much there, but and I know that I'm not allowed to. My time is already up. But what I would say is, I commend the court the 33E dive that you're going to do. The record I stand absolutely firmly behind the claim that this put race to the side. This was a remarkable takedown. That's the police officer's words. A remarkable takedown. 13 officers surrounded this car with at least one gun drawn, the guy who's the point man. They were all white, and there are 3 black guys in the car. There's no doubt that this was an overwhelming show of force. There's also no doubt, because the motion judge found it, that when they pulled Fisher out of the car and 2 officers put their hands on him and pat-frisked him, he was seized. He was not allowed to leave. The question, and put aside race, and this doesn't depend on race. Race is not dispositive. There's no dispute that he was seized by these cops, guns drawn. The question is, and then sitting next to him, his cousin says, "Can I leave?" And the cops say, "No, you can leave when we're done." He hears that. Now, Fisher gets taken to the side by 2 other cops, and they say, before beginning what the trial judge admits is interrogation in a homicide investigation, the cop says, "You can leave if you want to, but I want to ask you some questions." Fisher says, "Okay." And then they ask him the questions. What I'm saying is, that's all undisputed. Forget about race. That brief statement, "You can leave if you want to," before he interrogates him in a homicide, cannot undo what the court already found to be custody. You can't leave. So that's the core of that argument.
Didn't the court found the opposite?
No.
That he wasn't seized for constitutional purposes, such that Miranda was necessary?
Sorry, I want to be clear. The court found that when he was pulled out of the car and pat-frisked, he was not free to leave. That's what the court found. And then, when the officer took him to the side, and before he interrogated him, and he found this was interrogation, he said, "You can leave if you want to." The trial judge found that statement, "You can leave if you want to," transformed this not free to leave into free to leave. That's what the court found. And that's the point that point is what we're saying. That couldn't transform not free to leave into free to leave. That's what we're disputing. Okay? But just one last thing, because the braided hair, this is crucial.
I think we've heard about
Yeah,
the
didn't
braided
you already
hair.
talk about the braided?
Sure, I'm just going to say the girlfriend braided his hair. It's not relevant. The police, I apologize. Thank you very much. Thank you.
Okay, Attorney Elliott.
Thank you. May it please the Court, Assistant District Attorney Krista Elliott from Middlesex on behalf of the Commonwealth. The Commonwealth requests that this Court affirms the judgments against the defendant and declines to grant relief pursuant to 278, Section 33E. I will turn first to the issue discussed by my brother. The trial judge in this case did not abuse his discretion by allowing Trooper O'Brien to testify that he recognized the defendant as the same person captured in the hotel surveillance videos. I first want to address my brother's point that in his claim that this was the Trooper O'Brien's identification was the centerpiece of the Commonwealth's case. This identification was certainly not the centerpiece of the Commonwealth's case.
How is this different than Wadsworth?
This is significantly different than Wadsworth because in Wadsworth, the improper identification evidence was extensive. There were 4 separate officers who testified and presented different side-by-side photos, which contributed to the authority of those identifications that were being made.
By saying wasn't central, you're allowing, and I think you have to, that it was improper, correct?
No, we are not allowing that it is improper. We absolutely believe that the trial judge did not abuse his discretion. This was a fully litigated motion in limine hearing in which the decision was made after a fully litigated motion in limine
But
hearing.
I don't get how, again, it's a super witness, how a police officer can say, oh, I've got special eyes, that's him, and you're gonna find out it's him. How's a police officer able to do that when the jury should do that? I mean, the judge appropriately instructs at the end, that's your call. It's not the officer's call, but why is the officer doing it in the first place?
Well, because the officer has a special familiarity with, the judge has made that determination that the officer has a special familiarity with that witness that the jury cannot possess.
So are you saying that's more like somebody who knows a friend or something? You don't worry too much if I'm making an identification of Justice Gaziano in a photograph.
A colleague.
It is,
Colleague, sorry, not friend.
I would just say that it is certainly similar. It's not quite the same as if you have a friend, friend identification where there is some extensive multi-year familiarity, but certainly it is more similar to that. And
The jury has the same familiarity because they see the guy during the trial.
but the judge specifically found in this case that the appearance of the defendant was different at the time of the trial than his appearance was in the surveillance videos or during the stop. And here we do have some photos of the stop itself in kind of an unusual twist, given that there was a journalist who was on scene who actually provided photos of the stop.
I'm just trying to understand how this case will be limited. How won't police be able to do this every time? That the arresting officer, by watching video repeatedly, will always be more familiar enough to do this? Or how is this limited, I guess? Was that clear, my question? I'm worried that every time officers will be able to develop, the arresting officers will be able to develop this special familiarity with video.
Can I follow up with Justice Kafker's point? Because do you agree with your brother's seemingly take from Wadsworth that there's a bright line that we set out in that case, that if your familiarity is based on watching the video before you have any personal interaction, that you're out?
Yes, I do not agree with that assessment that that is what Wadsworth stands for. I will acknowledge that certainly the vast majority of our case law does involve a situation where a police officer has a prior familiarity before they watch a surveillance video. And I would also note that, unfortunately, the vast majority of the case law in this area is unpublished. And so I would draw the court's attention for whatever it's worth, acknowledging that this is an unpublished decision and it is persuasive only, to Commonwealth v. Barry. That was decided on August 3rd of 2017, and that's Appeals Court Docket 15P1508. That was a case that specifically found that a detective had sufficient familiarity from watching a surveillance video before going and then finding the suspect.
I thought our case law, if I remember it right, says something like they have to be familiar with the person, and it can't be from police interactions. So it has to be someone who knows someone from a neighborhood. A cop happens to know the person, not from doing FIOs. We've said that in cases. And this seems to me more of the FIO flavor than the I know him from the neighborhood.
And I certainly recognize the concern that is raised by Your Honor. I would note, though, that this, again, goes...
As we get more and more video surveillance in every case we see, these ground rules seem a little shaky to me, that we need to be clear to the bar and to the police and defense bar what the rules are, and not to have or sanction these super witnesses.
Certainly, and I simply don't think that we have a super witness here in this case. And I want to go back to the fact that the judge did, in fact, make a determination in this case after a full hearing that a single officer could make this identification. He specifically weighed the potential prejudice against the probative value and found that in this limited circumstance that this identification could occur. Additionally, there simply was no substantial prejudice to the defendant in this case.
I'm just trying to understand why, because I'm not saying you're wrong. I'm just trying to understand. So, again, the officer's familiarity with the defendant is just arresting him, right? And then he's given this sort of capacity to say that's him, I just, are there any limitations on that? I'm just trying to figure out what the limitations are going to be.
I think that certainly one of the limitations would be if looking at the quality of a video.
But if it's really clear, the police officer shouldn't testify.
Certainly, if it's very clear, then we wouldn't have one of.
You have this murky ground, which most of them are, frankly. Most of them are Hollywood quality, and the ones that like Davis that are just simply blurs aren't relevant. So what we're really litigating are the ones in between, correct?
That is correct.
And again, I just don't know how we sanction these police officers to testify. You might be saved by the instruction, I don't know. But I just don't get how this is different from Wadsworth, given the centrality of the identification to the case. I mean, and the fact that the prosecutor, rightfully so, uses it in her closing argument because it was allowed into evidence.
Well, Your Honor, I would respectfully disagree that the prosecutor utilized the identification in her closing argument. In fact, what she did was she specifically called the jury's attention to the fact that they needed to look at that video and make a comparison. And she actually cited to the booking photos and to compare the booking photos with what they were seeing in the surveillance video. She never actually invoked Trooper O'Brien's identification of the defendant.
I might have missed that. She didn't do that?
She did not invoke it. And I certainly would request that this court look at the citations that my brother makes, because I've reviewed all of those citations, and from my reading, there is no invocation of Trooper O'Brien's identification in closing.
I'm sorry, go ahead. Go ahead. Counsel, if I remember correctly, was Ms. Gattuso's ID, was that suppressed?
Yes, Your Honor.
So this would have been the only other evidence, independent of the video, of the identification of Mr. Fisher.
This would have been the only other direct evidence, Your Honor, but certainly there was ample other circumstantial evidence.
Is that what makes this different? Because that there would be no other, there was no other direct evidence but could we say that would just be tough luck for the Commonwealth if that's the case? I say that because, and I'm not trying to be glib, that we said what we said about police officers coming in and saying that's the person, and what the jury can infer from that because the police officer does that. And I take Attorney Wood for that point. We said that. But here there's nothing else. So is that part of the calculus for the judge in unmistakably clear? It's not unmistakably clear, and there's nothing else to help the jury here about because Gattuso's testimony's out. Is that part of the calculus, or should it not be?
I don't believe that is specifically part of the calculus here, because you are specifically looking at a discrete evidentiary ruling based on the video itself and based on what that officer is able to observe from the video and based on the other pleas factors. And those pleas factors do not contemplate porting in additional evidence that has or has not been excluded. And certainly I think if this court were to start pulling other factors based on the state of the Commonwealth's case into this analysis, I think that we would run into some significant difficulties with the court weighing in on the evidence itself.
So the evidence we have the video evidence is properly admitted. The problem is the officers, overlay on top of that. So we have his admission. It's the comment that June says to him, it's on the news. Mm-hmm. We have what does he say when he's arrested, the incriminating comment that he says when he's arrested?
There was the incriminating comments were not when he was arrested. It was when the car was when he was interviewed at the Burger King.
Say?
He specifically said that when he was asked where he was on the night of the crime, which had not been defined for him, he said that he was at work, and that would have been at Logan Airport. And then he also provided his phone number, and the officers recognized that phone number to have been one of the phone numbers that was in communication with co-defendant June's phone.
Okay, so And we don't have any CSLI, we have none of that here. Do we have any other identifying evidences that we haven't brought up in the briefs or? I haven't read the transcripts yet.
So the CSLI for the defendant only was very limited. There was not a CSLI that was admitted for the period of the crimes themselves, but the CSLI for the defendant does show that he was in Boston both before and after the crimes, which is in the approximate location where his co-defendant was. So there is that particular CSLI evidence.
And that correlates to the videos, right?
Yes.
Because you had the co-defendant going to Red Roof, to the other one, and ending up at the extended stay.
Correct.
And you had video of Mr. Fisher in all three.
Exactly. So we do not have the CSLI of the defendant's phone at those locations, but we do have him on video with his CSLI showing that he and the defendant were in Boston both before and after the crimes.
Because this is distinctive clothing. Is any of this clothing found?
Yes, the defendant's, is presumed to have been the defendant's pants that he was wearing in the videos was in fact found during the search warrant of his house, and that those pants were in fact introduced into evidence.
I mean, I thought the shirt was distinctive. What is it about the pants that's distinctive?
The pants have kind of a cinched bottom to them. They're black baggy pants with a cinched bottom. Certainly the shirt that co-defendant June was wearing is far more distinctive than the pants, but the pants that were consistent with what the defendant was wearing.
Everything you got, because the briefs, I mean, there are a lot of issues raised in the briefs, so everything about identification that could lead us to saying that the cop's overlay was not prejudicial.
Of course. So first, there is the defendant's statement regarding his alibi that shows consciousness of guilt. We have the confirmation that he did in fact have similar braids to what is seen in the video at the time and at the time of his arrest by his girlfriend, who testified that she had in fact at that time done his braids for him in that style. We have his communications with his co-defendant in the immediate aftermath of the murder. The two of them were in constant communication, and that the phone records are included in the Commonwealth Supplemental Record Appendix, including that one text message statement from June to the defendant saying it's on the news. There's also the fact that the co-defendant June changed his phone number immediately after the murders, and the defendant
There's a ton of evidence on June. That's not,
yes.
It's how much, focus on Fisher.
Of course, and then the defendant Fisher started texting that new phone number, and so clearly indicating that the two were in communication around that phone number switch. The pants that were found in his house, as I've already discussed, is certainly evidence of the fact that he was the same person in the video. The descriptions that were provided from Gattuso certainly match.
Quite match, right? Because someone describes the person, the first sex worker describes him as 5'4", right? And he's a much bigger guy, right?
She describes the defendants as approximately her height and describes herself as, I believe, around 5'4".
How big is June?
He's, I believe, a little bit shorter than the defendant is. So certainly there are some inconsistencies there, but the testimony was also that Michelle Gattuso was on the floor with a gun to her head for the vast majority of this interaction. And then, as we've already discussed, the other identification evidence, or evidence that goes toward identification, is that the defendant's cell phone location was in Boston both before and after the crimes, along with co-defendant June at the time. And so for all of those reasons, the Trooper O'Brien's identification simply did not prejudice the defendant in any meaningful way. I also think it's important to focus on exactly what Trooper O'Brien did testify. He specifically testified really only about 2 separate instances where he was identifying the defendant. And in the first, he testified that he recognized that the person in the front passenger seat was the same person he had seen in the extended stay video the night before, and that was Derrell Fisher. It was uncontested that Derrell Fisher was, in fact, the person who was in that front passenger seat. And so it was a very brief bit of testimony at that point. The only other testimony in which he was identifying the defendant was where he testified that based on this surveillance video, which was the Saugus surveillance video, I believed that it was the same person in the extended stay video from Burlington, the Red Roof Inn Plus video in Woburn, and I believed that it was Derrell Fisher. This was not a completely unequivocal statement of surety. It was, I believed that this is who this person was. And that absolutely comports with the instructions that the jury then received at the end, where they were told, you need to make this determination. You have to be the ones who decide who it is in that video. And the jury was further instructed that they needed to determine whether or not Trooper O'Brien was either incorrect or making a false statement. They were explicitly instructed both contemporaneously or at the close of the direct exam of Trooper O'Brien as to this fact, and they were instructed during the general instructions at the end. And so for those reasons, there simply were not, there was not prejudice, even if this was an improper identification. I will turn next to the question of the suppression, since that was hit upon it briefly by my brother. And in this case, the motion judge properly denied the defendant's motion to suppress, where his statements were not a product of custodial interrogation, and he was thus not entitled to Miranda warnings.
Are there cases where someone's in custody then not in custody?
I have not specifically looked for a case where someone was in custody and then not in custody, but here,
It seems odd to me that, you know, with all due respect for Judge Fishman, the police take down this vehicle, he's hauled out of there, one person's told they can't leave. It's clearly he can't leave, it's custodial at that point. And then when they speak to him, they say, oh, you can leave. Now he's not, now he's magically not in custody. I'm just wondering if there are cases that say your custody status changes.
Well, we certainly have cases that talk about how a Terry stop does not necessarily arise to custody and things of that nature. I certainly recognize what Your Honor is saying. I think that we do have two very distinct...
There are Terry stops and then there are Terry stops.
Of course.
All right, so there's the, hey, come here, I need to talk to you.
Mm-hmm.
And then there's the, you know, takedown.
Of course, and I think that takedown, it does not actually adequately describe what happened here. We had the three men who were in this vehicle. Police did come up to
The blue lights and a gun drawn, right?
but there is no evidence on the record that any of those men in the vehicle saw that gun drawn. There was a gun drawn, but even the defendant's own witness, Romaine Price, did not testify that he saw a gun drawn. So there's simply no evidence that that was what any of those.
How many cars stopped the defendant's vehicle?
There were, I believe there were 3 officers initially on scene from Woburn who had originally seen the vehicle.
In one police car?
So they weren't in one police car. I simply don't recall if it was 2 or 3 police cars. But of course, the vehicle was stopped. The police came up to the vehicle, and while the men were still inside that vehicle, they were also explicitly told that they were not under arrest and that the officers were interested in the car. They were told that the officer said, you may have had nothing to do with this. We are interested in this car because it may have been involved in a crime. And so when the defendant was asked to step out of the vehicle, that would have been his understanding at that time.
Pat first.
I'm sorry, what was that, Your Honor?
Pat first?
He was pat first once he got to the back of the vehicle. And so Judge Fishman specifically said that he was not free to leave at that point.
Right, so I'm wondering if we have any cases or if you're aware of anything where someone is taken down, pat first, not free to leave, and then all of a sudden they're free to leave. I'm not aware of any, but are you?
I am not personally aware of any. Off the top of my head, I can certainly do a little research into that and submit a letter if Your Honor would appreciate it.
I would.
Okay, of course.
And it might be the opposite as well.
Of course. I will certainly submit that letter. But regardless, here we have a situation where it is, assuming that we are at a point where the defendant is now far away from the vehicle, which he walked over to a separate portion of the Burger King parking lot. He was explicitly told, you are free to leave, you're not under arrest, asked a couple of very basic questions, and of course acknowledged that he was free to leave. He was asked a few very basic questions, and then ultimately did leave the area. He went behind the Burger King.
Was he handcuffed at any time?
He was not handcuffed at any time. None of these men were handcuffed at any time. So he went behind the Burger King, he spoke with his friends, he spoke with the Burger King employees, he went into the Burger King, he ate his Burger King meal, and then asked the police to call a cab, and ostensibly left in the cab. He was not arrested at that time. Simply none of the factors weigh in favor of determining that the defendant was in custody under the groom factors, and the motion judge properly denied the defendant's motion to suppress. there are no further questions, I would rest on my brief.
There was one question I
course.
had. In response to a question or the issue of an accident instruction, you write that in a felony murder case, you don't get an accident instruction.
Yes, and the Commonwealth acknowledges that our brief should have probably more artfully said it is unclear at this point whether or not a defendant would be entitled to an accident
Do
instruction
you think
post-Brown.
Right, do you think that law survived Brown?
I would say that it may not have survived Brown, but
I think you're right.
certainly there was no entitlement to an accident instruction here.
All right.
Okay, thank you very much.